Now, this session basically is on legal research and writing. We have two sessions scheduled. One is for legal research and writing, and others for case analysis and journalism. So, if anyone of you is interested, you might also join the other session that will be at 1 o'clock. Now, let's begin with research. So, research basically is a very general term that we all use in our day to day life, especially being law students and people who are in the field of law. Research basically means we have an idea or we have a theory and at hand. What we do is we try to dig deeper into that and try to explain it in more creative manners, try to come up with newer concepts or methodologies and understandings. So, investigating or experimentation that is aimed at the discovery and interpretation of facts, revision of accepted theories or law in the light of new facts, or the practical application of such new or revised theories of laws. So basically, this slide has the definition of what legal research and research. Now, as I said, research in is a very general concept that we talk about, and very general word that we use in our day-to-day lives. So, research basically is the creation of new knowledge, or the existing knowledge in a newer way. What legal research is? Legal research is investigation and experimentation. Why? To discover or interpret the facts or to revise the accepted theories or laws in new lights. Because law, as we all know, is a dynamic subject. It is not a theory that once a theory is formulated, there cannot be any change in that. Law is very dynamic, changing day to day as the needs of society changes. Hence, investigating and experimentation that we do to interpret facts in a new way or to revise the accepted theories or to understand the law in various practical ways is known as legal research. Now, when we talk of research, there are various research methodologies, that is, methods that we use for writing a research paper, for doing our research. Now, firstly, we'll talk about 8 of them, and the remaining two we'll discuss later on.
Ma'am,
In
are you changing the slides?
yes, Paras, is there an issue in that?
We are on the first one.
Okay, just let me see, please. Let me reshare my screen. Which slide are we on now, Paras? Could you please tell me?
Types of legal research methodology.
Yeah. Okay.
Descriptive legal research.
Yes. So as we were discussing types of legal research, first we'll talk about descriptive. So descriptive legal research, as I have explained it here in 2 lines, it delineates the current state of a phenomena, focusing on what has happened and what is happening without probing causation. That is, we do not go into why a particular thing is happening. Now, for example, when we try to explain descriptive legal research, we say key in descriptive legal research, we systematically record and report the observations that we have made to identify the trends and patterns and general characteristics without exploring the causes or relationship. Now, as I've written here also, we do not go into what has happened or why it is happening. That is, we do not go into the causation of things. Now, for example, we I'm sure you all have heard of the word census. So a national census collection data on various demographic factors including age, gender, income, education level, occupation, to describe characteristics of population. This is something known as a descriptive legal research, and this is a very good example of descriptive legal research. Then we have the analytical legal research. Now, analytical legal research aims to understand the underlying causes and relationships between the various factors, often using statistical techniques to test hypotheses and draw conclusions. Now, the main difference between descriptive and analytical is that in descriptive, we do not go into understanding what is happening or why it is happening. But in analytical, we try to examine the underlying patterns and implications to understand deeper meaning behind the legal phenomena. Now, an example of this could be when we study a relationship between socioeconomic status and access to healthcare. Now, socioeconomic status is what? The education level, the income that they earn, the society that they belong to, and how does it affect the healthcare that they get. So, understanding the reasons behind why a particular group is getting a particular kind of healthcare is an example of analytical legal research. Then we have applied legal research. This seeks practical solution to real world problems, operating within practical context to address pressing issues effectively. Now, applied legal research basically is a problem oriented legal research where what we do is there's a real life problem. We try to seek solutions to those problems. Now, an example of this could be, when the government was coming up with the use of solar panels as an alternative source of energy to reduce the combustion of various fossil fuels and to preserve our nature. That is one of the examples of applied legal research. Then we have the fundamental legal research, or also known as basic legal research. Fundamental legal research aims to advance theoretical understanding, focusing on expanding knowledge rather than immediate application. What does this contribute? This contributes to creating a theory rather than finding problems. So, to explain this in simple terms, in applied legal research, what we do is we come up with solutions for the problems that the society is facing. In fundamental legal research, it is more curiosity driven. Why we do this? To understand and to expand our knowledge. Now, this could be if any one of you has ever studied physics, you might have heard of quantum particles or the word quantum mechanics, right? So, investigating the properties of quantum particles to understand quantum mechanics better can be one of the examples of fundamental legal research. Then we have quantitative legal research or quantitative research. So, quantitative research basically relies on numerical data to understand quantifiable aspects of legal phenomena. Now, quantitative, as the word suggests, it uses statistical methods. We have numbers, we have various questionnaires, and we have various data that we use to test our hypothesis, that is to prove or disprove a particular statement. Then we have qualitative legal research. Qualitative legal research, it explores humans' behavior and social context through non-numerical data, capturing the complexity of the subject matter. Now, in qualitative legal research, quantitative, as the name suggests, we use various what do you say? We use various data, we use various interviews, we use various methods like surveys and experiments to come up with a number and to test a particular hypothesis. But quantitative legal research, in qualitative legal research, what we do is we explore the quality and characteristic of human nature and legal phenomena. Then we have conceptual research and empirical research. So conceptual research, it focuses on developing ideas and frameworks to explain a phenomena, advancing knowledge through new concepts and theories without necessarily collecting data. But in empirical research, we rely heavily on data and we use facts to substantiate our hypothesis and provide uh, empirical evidence to support or challenge our legal theories, or if not legal, even in normal cases, empirical research, if you anywhere see the word, you should be able to understand that in this particular research or in this particular um, research paper, the researcher or the author has used a lot of experimentation and has done various surveys and has collected data to substantiate his or her hypothesis. But if it is conceptual, we are relying solely on understanding and explaining legal framework. We do not go into using various numbers and data and doing surveys and etc. to collect data. We already have some existing research done. We have literature on that, and we only use that. Now, coming to our topic, that is legal research. So, legal research basically is taking clue from the meaning of research. Now, as research, we understand is what is the creation of new knowledge or the use of existing knowledge, right? But when we add the word legal, it may be defined as systematical investigation towards increasing the sum of knowledge of law. Exactly like what research does, what we it increases our knowledge of a particular concept. Similarly, legal research is a systematic investigation that we do to increase our knowledge of law. Legal research is the process of identifying and retrieving information necessary to support our legal decision making. It includes in it each step of a course of action that begins with the analysis of facts of a problem and concludes with the application and communication of the results of the investigation. Now let's understand this in two ways. Firstly, imagine you are an advocate, a practicing advocate. Now your legal research, now if you want to do legal research relating to your particular case, what will be your first step? Your first step will be to understand the facts, to understand what the problem is. Then you'll find out what research needs to be done. You'll do that research, you'll see if how that particular research that you have done or a particular case law that you have found is applicable in your case, and then you'll come up with a result and you'll write it down in your arguments. Similarly, while you're writing your research paper, you have a question at hand or you have a research problem at hand. Now, once you have that problem, you'll start fact finding and digging on what the issues are, what is needed to be done to solve this particular problem. You'll do research on that, and then you'll build your research paper on that to either prove or disprove a particular hypothesis if you have created any. So, research basically is a step-by-step process that includes fact-finding, digging of various research articles, case laws, and relevant other sources of research, including primary, secondary, and tertiary, to support your arguments. Now, when we talk of legal research, we specifically use these four ones a lot. That is doctrinal research, research in theory, empirical investigation, and reform-oriented research. So doctrinal research is one of the most widely used research by research scholars of law. What it is that you already have existing legal rules, principles, doctrines, case laws. What you do, you examine and analyze those things. It aims to systemize the existing law to what? To evaluate its effectiveness. We do not go into the reason of what the law, why the law was made, or what the law was before it. We just have a law or we just have a legal theory and we analyze it, we examine it to understand its effectiveness. Then we have research in theory. It focuses on conceptual foundations of legal rules and doctrines. Now, as we studied the conceptual research part, what we do, we have a concept, we just dig on that. We do not use a lot of fact finding or data. So that is research or theory. This serves as a basis for empirical research and helps in the development of law through legislative, judicial, and administrative means. Then we have empirical investigation. Empirical is what? Empirical is use of data. So in empirical investigation, we examine the practical impact of law by exploring its social, political, economical, and cultural effects that it had on the society. This type of research, it highlights the gap between the theoretical idea and the real life outcomes. Now, whenever a law is made, there is a particular concept or idea in the mind of the legislature that is making the law of what needs to be done or what the problem is. And so they implement a law. When we do the empirical legal research, what happens is we have the theory at hand that we got from the research or the doctrinal research, and then we have the data that shows what has happened or how the law has impacted the society. So this particular kind of research, it highlights the gap if there is any, whether the law was effective or not, or what other reforms needs to be made in that particular law to ensure its full effectiveness. That is what empirical investigations are. Then we have reform oriented research. Now, this uses empirical data and critically analyze to propose changes in law and legal institutions. It seeks to improve our legal system based on the evidence and evaluation of all the current practices. Reform basically means to bring about a change. So, any kind of research that is done to bring about a change or to suggest new laws, suggest new changes, or to suggest any particular reforms is known as reform oriented research. One of the best example of this, you can for that you can read the law commission reports, because every time a law commission report comes out, you'll see that they do suggest they do analyze the data and the facts and the outcomes of a particular law, and they also suggest reforms of what needs to be done to ensure that the betterment of society. So that is one of the example of reform oriented research. Now, coming to steps of writing. The first one is, what is your research question? The second is to identify your headings and subheadings. Then it is to make a rough and filling information, and the fourth is revision and editing. Now, what is your research question? When you go to write a particular research paper or a research article, you first need to have a research question or a problem at hand. Once you identify your research problem and formulate your research problem, you can start digging on that. So what is your research question? Now there are a few pointers that you need to remember while you're trying to understand what your research question is. It includes what is the specific topic or issue that you're investigating. Are there any particular aspects of that particular topic, or do you want to explore it the whole? Say for example, you take the topic of divorce laws. Do you want to explore each and every aspect relating to divorce, or is there a particular aspect that you want to investigate? Say, for example, you want to investigate only relating to maintenance or alimony. Do you want that specific topic, or do you want to research the whole divorce law? What do you want to do? That you need to find out. Then, how does your research question contribute to existing knowledge or address the gaps in the literature? As we have studied the definition of research, what is research? Research basically is the process of creation of new knowledge or ideas, or you use the existing knowledge or ideas to come up with newer perspectives, newer interpretations. So, what impact does your research have on the society? Is it even beneficial, or is it just something that you're doing? You need to find out that, because until and unless your research contributes something or addresses a gap in the already existing ideas, your research will not have a substantial impact. So these are a few questions that you need to have in mind, that you need to answer to while you're formulating your research problem. Then we have identifying your headings and subheadings. Now, when you usually write your research articles, there are various headings and subheadings that you need to understand. What are the main categories or themes you will be investigating on? How can you break down into various subjects to help people understand your research better? And how will you organize them? Your research article or the research paper that you're writing, it needs to be structured, because without a structure it will be a wild goose chase to understand what the particular researcher is trying to explain. So What you need to do is, before even you start writing your research paper, you need to identify your headings and subheadings, put them in an order and in an order that makes sense. Identifying your headings and subheadings will also help you to it'll also help you create your draft in a much better manner, because you'll know what you need to write. If you only have a question at mind and you do not identify your headings and subheadings, you'll just go about writing anything and everything that you see related to that topic, which again will not be useful, because there'll be a lot of information that is unstructured, and unstructured data or information will be of no use. So first step is to identify what your question is, and second is to identify what your headings and subheadings are. Then making a rough and filling in information. What are the sources? There are three kinds of sources of you can refer to, that is primary, secondary, and tertiary. So what kind of sources will you be using to gather your data or evidence related to your research question or research problem? If you have a problem, you obviously need a solution. So what will you use? What kind of data you'll use to come up with a solution? Whether you'll do surveys, whether you'll take questionnaires, whether you'll have any um, what do you say? Whether you'll have an interview, whether you'll have a group discussion, what will you do to come up with solution? Or will you just use doctrinal method and use the already existing data, already existing case laws, and already existing and available sources at hand to write your research paper and to answer your question? What will you do to answer is what you need to do to fill in information. Then the second question that you need to answer is, how will you organize and record this information to ensure that it aligns with your chosen headings and subheadings? In the previous points, you have chosen your headings and subheadings. Now, the data that you're collecting, it can be either through doctrinal sources, that is, using your already existing knowledge from textbooks, commentaries, case laws, discussions that have already happened, law commission reports, or the data you have gathered from doing interviews, from doing surveys or distributing questionnaires. Now you have all this data. How will you fill in and ensure that it aligns with your headings and subheadings? For that, while you're doing your research, you need to ensure that you are researching on that particular specific topic that aligns with your research problem. You cannot go asking about 10 unnecessary questions in your questionnaires and expect it to be useful in your research when they are not even related to it. Say your research is relating to maintenance and alimony, but your questions are related only to marriage and what the people are going through in their married lives. You have no questionnaire, or even in your interview, have not asked questions relating to maintenance or alimony laws. How will you expect that particular data to be useful for your research when it is completely related to maintenance and alimony, right? So whenever you're doing your research, whenever you're making your questionnaires, whenever you're going for interviews, ensure that you know what you want to achieve while writing your research paper, and investigate only on those particular points. Then, revision and editing. How will you review and revise your research findings to ensure they're accurate, relevant, and coherent? How will you do this? Firstly, after you have done your writing and you have arranged it, read through it correctly. Ensure that there are no grammatical errors, and to ensure that your data is correct, go on the websites, go on the internet, read more articles, more journals, more research papers related to your topic, to ensure that what you have written aligns with what they have written. I'm not saying that the facts or numbers that you have mentioned need to align, because numbers keep changing. Your data might say X, their data might say Y, but the theoretical aspect of a particular thing needs to be similar. So ensure that once you have written your article, you go through others' articles and read that the theory aligns or not, because theory isn't changing. The interpretation might change, but the theory won't change. The main concept won't change. So ensure read your article twice, read your research paper twice, read others papers, and try to understand if there are any inaccuracies or if there is any irrelevant aspect, remove it. Are there any further need to analyze or clarify? Now, after you have written your research paper and after you have read it, then only you will be able to answer the question if there is a need for further analysis or clarification. So find that if there is a need, if there is a gap in your research paper, or if there is a gap, or if you ever think that the research question that you have started is not being answered by your research paper, then do more analysis, take your time, try to understand what is missing and fill in that information as well. Now, coming to the stages of writing your article, when we talk of stages, I have mentioned 8 of the stages that we use while writing a research article. First is identification and formulation of your research question. What you need to do to ensure that your first stage is done is identify a broad area of interest. Say, for example, I have interest in laws relating to marriage. Then I know that I want to do something in this particular field. Then narrow it down to a specific subject matter. Now, the subject matter that interests me, say for example, is law relating to maintenance, which I feel is very unfair and unjust in India. So I'll take that. Then focus on a particular aspect or question within that particular subject. Now, as I said, my interest in the law is in the law relating to maintenance. But on going deeper into that, my point of view is that the law relating to maintenance is very unfair to a particular to the particular male society in our country. So this is the specific question that I want to answer in my particular research paper. Your research problem or your research statement is the starting point. It needs to be well defined and very clear. Because if your research question is unclear, then the people won't understand what even are you trying to accomplish while writing your research paper. So the question that you formulate needs to be clear and not vague. You cannot make a whole big issue, take a big issue and go about it round and round and round and create a problem. You need your research question needs to be crisp, it needs to be very clear and well written. You do not have to write a 4 to 5 line question explaining why you're doing this. Your research question is hardly of 1 to 2 lines of what you think the problem is and why you're doing this research. Then the second step is the review of literature. Now, review of literature basically means you gather and analyze the existing literature that is there related to your problem. Say, my problem is that the law relating to maintenance is unfair to the male population in our country. If there is any existing research related to that, it can be either directly related or indirectly related. I find that literature and then I analyze it on what they have done and what they have accomplished in their research paper and what are the gaps in their research paper, what I will be doing. So, what you do is you search for various articles, case reports, journals, and various relevant books related to your particular topic. You evaluate their findings and the type of research methodology that they have used. And if there are any unexplored aspects in the research paper, if there are any gaps in the research paper, you highlight that and and you highlight that and then you write what your research paper will be trying to accomplish. Then is the formulation of hypothesis. That is, it is not necessary that each paper has a hypothesis, but mostly it is there. The hypothesis basically is a Greek term which means hypo means under and thesis means under the and thesis means idea or thought. So basically, hypothesis, when we put it together, it means an idea or a proposition that is under scrutiny or under evaluation, or it is evidence to test its validity. Now, A hypothesis is basically a statement or a generalization which can be tested using empirical data, that is, empirical legal research. How to develop a hypothesis? The first is you need to know what you want to test in your particular theory. Say, for example, I want to test that the maintenance law in a particular country is actually unfair and unjust to a particular section of the society. I want to test this. So what I'll do, I'll do researches, I'll do surveys, I'll give people questionnaires, I'll do interviews and collect data that either supports my hypothesis or disproves it. When I collect the data, it the hypothesis is a general statement. It is something that can either be proved or disproved. Say, for example, I want to prove it, so I'll collect data to prove my hypothesis that yes, the law relating to maintenance laws in my countries are gender biased. So that is what a hypothesis is. It is a statement that you write which can be proved by using relevant empirical data. Then is the research design. Now, research design basically means how will you conduct your research and what methods will you be using to collect and analyze the data and how will you structure your study. You might have seen research papers and dissertations and um, thesis written by various research scholars in which there's a part known as research methodology or research design that explains what kind of method you will be implementing in your particular research paper to collect data. Then is the actual collection of data or gathering of data. This involves using both primary and secondary data to gather evidence, and it includes collecting data, doing surveys, doing interviews, group discussions, etc., and also uh, all using already existing data. Say, for example, I want to say in one part of my research paper that in this particular age, okay, in or in the particular past 2 years, we have witnessed a rise in number of domestic violence cases against men. There, how will you get the data? Because many people might not be able to, give you accurate answers. For that, you can use the already existing data. By that, I mean the National Crime Records Bureau's data that analyzes, how much crime has occurred in the particular year and what kind of crime has occurred. So I can use that data. So using already existing data and gathering new data from interviews, surveys, and group discussions, etc., is the process in which you collect the data. Then the sixth step is analysis of data. Now you have collected the data. What is the next step? The next step is to analyze it. So what are the patterns that you see? Are there any trends or insights? Now, this analyzing data also includes organizing and preparing data for interpretation. What you collect while you're doing research, interviews, or surveys is a raw data. You cannot put raw data in your research paper and expect it to be published. You need to organize it in a way that when a person reads it, they understand the trends, they understand the patterns of what you have tried to accomplish. So you can organize it by, say, I'm talking about male and female. So I can organize it by their demographics, by the places that they live in, by their gender, by their age. So once I organize that data by using tables or by using graphs, then I'll put it in my research paper and try to interpret it, which is the seventh step. Interpretation of data basically means drawing conclusions from the data. It involves linking the findings to the research problem and understanding the broader implication. Now, my research problem that we are talking about is that the male population is at a disadvantage when it comes to maintenance laws in my particular. I have analyzed data and I have an answer relating to that. Now, I'll interpret it. It can either prove or disprove my hypothesis, right? So whatever it is, I'll try to interpret the data and find the broader implications of the particular data. And then is your research report. Research report is basically once you have all your data done and all the interpretation done, then you write the research report or the research article or the research paper that we're talking about. We have in this the preliminary pages that have the indexes, acknowledgements, table of contents, and the introductory element where you introduce your topic. Then we have the main context in which we uh, define our methodology, our chapterization, then the findings and conclusions, and fill in the data. And then in the end matter, we have the bibliography, appendices, and indexes. So that is what your research report is. So before you write the research report, there are 7 steps that you need to complete. Firstly, you need to identify what the problem is. You need to find uh, literature or already existing articles relating to your topic and analyze it. Then you may or may not formulate a hypothesis completely upon you, depends on what your research is. Then you try to understand what your research design is, that is, what is the methodology that you'll be using. Then you collect data using that methodology, you analyze it, interpret it, and once you have interpreted it, you write your research report. Now, as I said, that there are 2 more kinds of researches that we have left while we are talking about kinds of research. So those 2 kinds are doctrinal and non-doctrinal legal research. So doctrinal legal research basically means it is also known as an and library-based research method. Why? Because in this you have the statutes, you have the rules and regulations, you have textbooks, you have commentaries, you have case laws that are already available at your disposal, whether in hard covers in your libraries and other places that you read at, or they're available in the internet. And what you do, you analyze those things. You do not go take a step ahead to go into the field or get into the field to take surveys and take and do discussions. But whereas non-doctrinal, it is a research in which you go out to the world, you do surveys, you do field studies, you do statistical analysis to understand the real world implications of a particular thing. Now, the meaning of doctrinal legal research, as it is written here, is it focuses on the analysis of legal principles, doctrines, and case laws. It involves studying statutes, regulations, and judicial decisions to understand and interpret legal doctrines. Exactly what I said, you do not have to go a mile away to do surveys, do analysis, give questionnaire to people. You have everything at hand, whether it is the statutes, regulations, or case laws, whether it is the textbooks you'll be referring to. You have them at hand. What you do is you use these all things to understand a particular concept and to interpret it. Whereas in the non doctrinal legal research, it focuses on the empirical and practical aspect of law and often involves the study of how laws are applied in practice. It includes field studies, surveys, statistical analysis to understand real world implication. So, the major difference between the doctrinal and non doctrinal legal research is how we do them. In non doctrinal legal research, we apply various modes of legal research. We use empirical data, whereas in doctrinal, we do not use any kind of empirical data. Then the aim of doctrinal legal research is to clarify, explain, and develop legal principles and doctrines. It uses theoretical understandings to understand the interpretation of legal texts. Whereas in non-doctrinal legal research, we use law, we use various surveys, we use various questionnaires and other methods, and um, apply empirical data to understand what the law has achieved in the society and whether the laws have been effective or not. We take a law, say for example, I talk about law relating to uh, cruelty. So when we talk of law relating to cruelty, if we do doctrinal legal research on that topic, we'll just take the law, we'll see various case laws that are available, we'll see various textbooks or research articles that are available and interpret that particular section relating to cruelty. But when we talk about non-doctrinal legal research, what we'll do is we'll try to understand that has the law achieved its purpose. Law always is implemented to serve a purpose, right? So is that purpose served or not is the question that will be answered in the non-doctrinal legal research. Then the tools used. So in doctrinal legal research, the tools that are used are statutes, case laws, legal commentaries, etc. But when we come to non-doctrinal, we use surveys, interviews, case studies, and any other field work or observational techniques that are applicable. Then each of these methods has its own advantages and disadvantages. So firstly, we'll talk about the doctrinal method. The advantages of doctrinal method are that the doctrinal legal research provides quick answers to legal problems and utilizes well-established periodicals and indexes for comprehensive research. We do not take any random paper or we do not take any random source of information that we have in doctrinal legal research. We only take the established ones. We only take the actual case reports that are available in doctrinal legal research to answer our question effectively and quickly. Then it tests the logical consistency and soundness of legal propositions, contributing to development of well-structured legal doctrines. And the third advantage is that this type of research offers a detailed logical exposition and analysis of laws and doctrines, revealing inconsistencies and uncertainties in the legal principles. So, if the a law we all read, but the interpretation of a particular law will be different for me than it is for you, and the third person will have his or her own another interpretation. So, if there are any kinds of inconsistencies or uncertainties that is highlighted in the doctrinal source of legal research, then the limitations of doctrinal method of legal research. The analysis is very subjective and it is a reflection of what the researcher thinks, which may result in varying interpretations of the same legal issues. So that is one issue with doctrinal legal research. The second is that the research may be limited, maybe what the research actually is limited to theoretical analysis, and the real world implications are very less because sure we use case laws, but how it is how a particular law is helping or how it is causing chaos in the society, that is not fully explained in doctrinal legal method. Then the third is that it may overlook extra legal factors such as social prejudices or economic influences. It can be disconnected from practical social context and contemporary issues. Now, the limitation basically says that when we are doing doctrinal legal research, we only focus on what the law is. We do not focus on the causation or how it is related to various other socio-economic aspects. So that is one of the limitations of doctrinal legal research method. Then we have the limitations, more limitations of doctrinal legal research method. So the fourth limitation is that fourth advantage, firstly, of the doctrinal legal research is that it highlights loopholes, gaps, and ambiguities in the law, encouraging legislative amendments. Then doctrinal research facilitates the development of new theories. And the sixth is that it allows predictions for future direction and content of legal principles and doctrines. So basically, when we do doctrinal legal research, we analyze law from the history to the present day interpretation. So when we do that, we also give a room for predictions of what future directions might be. Then coming to the limitations of doctrinal legal method, the fourth limitation is that it does not address the social factors. Now, law is not a subject in itself. Law is related to economics, it is related to sociology, it is related to psychology, it is related to various other fields of studies, including science, including humanities, including commerce. So, when we do doctrinal legal research, we do not connect law with these particular aspects, and that might not lead to actionable legislative or policy changes. Then the predictions that we do from the doctrinal legal research may not always be practical. It is just that this particular precedent is going on and we expect this precedent to be going on. There might be a certain change, 1 or 2% changes in this precedent, but that is what we expect. We do not rely on any empirical validation for this particular prediction, hence it might not be a 100% accurate. Then we have advantages and limitations of non-doctrinal legal research. The first and the most important advantage is that non-doctrinal legal research highlights the gaps between the legislative goals and the social realities. That is, whether a particular law has served its purpose or not is something that non-doctrinal legal research explains. The limitation, on the other hand, is that it is very costly and time consuming, and not everyone can do non-doctrinal legal research as it demands extensive training. The second advantage is that it assesses the role and impact of law in achieving socio-economic justice, providing insights into how law has effects on social values and behaviors. That is, as we know, non-doctrinal legal research connects laws to various other subjects, including socio-economics and policy decisions. So, the advantage of non-doctrinal legal research is that it assesses the role and the impact of law in achieving socio-economic justice if it has done so. The limitation, however, is that we need a strong foundation in doctrinal research to for effective social legal research. Without it, the research may be ineffective or yield no significant results. So, if you want to do non-doctrinal research, you also need to have a good command on the theory of the concept and the doctrinal legal research, which some people might not have. Then the third advantage is that this research provides valuable feedbacks to the policymakers, legislators, and judges, helping them improve the formulation of new laws or to enforce laws in a better manner. The limitation is that basic data tool collection like interviews, questionnaires are complex and require specialized knowledge and skills. Because if you ever have done non-doctrinal legal research, or if you ever have gone for interviews, or if you have ever tried to make questionnaires, then you'll realize that it is not as easy as it looks, because hundreds of times people who you give questionnaire to, they'll either not write accurate answers, they'll not be willing to answer at all. Similarly, if you go for interviews, the same thing happens, that people might not even be interested in listening to you or giving you your time. So it needs someone who is good at this particular job. You need a set of skills to take interviews and to understand their point of view and to communicate with the local people. So that is one of the limitation of non-doctrinal one. Then the fourth advantage is that it helps in shaping social legislation to align with social engineering philosophy of modern states, making laws more effective for socio-economic transformation to achieve socio-economic justice. The limitation is that public opinion and social factors can influence the direction of legal research, making prediction about legal changes uncertain. Now, while you take interviews or questionnaires or collect data, there is always personal bias. For me, what is good might not be good for other person. Say for example, I agree to the particular tax slab. The other person might say, no, it's very high, and I earn this much. Half of my money is going in tax. What's the use? So it is personal bias. Personal bias comes a lot in non-doctrinal legal research, and that is one of its limitations. Now, what happens is that when there is personal bias, both on researchers' end and at the end of the people who are giving their interviews, the objectivity in our findings or the conclusions that we come up with are not always present, because we have already been impacted, and it affects our findings and our understanding. So that is one of the limitations of non-doctrinal legal research. Now, coming to what are certain things that you need to remember while you're writing your article or while you're writing your research paper. Firstly, it's the length, then the language, then the scannability and the jargons. This is specifically while you're using doctrinal legal research method. Now, every research journal that you would want to publish in would come with a set of guidelines. It is important that before you even start writing your research paper, you go through the guidelines, see what is the length of the research paper that you need to achieve. Some might say 2000 words are enough, some might say you need to write a minimum of 6000 to 10,000 words. So, what is the length of article that you need to write? Is something that you need to remember. Try to achieve that number or anywhere close to that number to ensure that your article is accepted. Then the language and grammar. Always ensure that the language and grammar of your research paper or research article that you've written is accurate. Especially in doctrinal legal research, what happens is if you ever copy paste from anywhere, then the language definitely will differ. So even if you have copy pasted from somewhere, reread your article to ensure that the language and grammar are correct. Say for example, somewhere you have written in as active voice and in some place you have written in passive voice. It won't make any sense. So the language and grammar must be correct. Then is the scannability. Scannability basically means that if I see your research article or research paper at glance, if the headings and subheadings are well defined, then we'll be able to understand the concepts that you're going to explain in your article in a quick manner. So define your headings and subheadings nicely to ensure that the reader, say for example, uh, Paras's article is being published, right? If he has defined his headings and subheadings nicely, it will be easier for the judging committee, for the and for the reader to understand what the person wants to is trying to achieve in his or her article. So do that. Then explaining jargons. As law students, as the members relating to law, it is one of the I'd say features that we all have, that we use fancy legal jargons a lot. We use fancy English terms as well as Latin terms and maxims. So if we ever use those maxims, if we ever use terms that a common person is not able to understand, then you also need to explain those terms. If you use a Latin maxim, say you use that maxim audio alterum partem, you also need to explain that particular maxim either in brackets or in inverted commas or whatever. Explain jargons to make it easier for the person to understand. So, for example, you have written an article very nicely, but the language is so tough that a normal reader cannot understand it, then it will create a problem, and uh, one might quit reading your article in the middle, no matter how good it is, because they're not able to understand. So, use normal English, which is grammatically correct. And if you have ever used jargons, try to explain them. Then this is one of the basic format that you follow while you're writing your research articles. Firstly, you write the abstract and keywords in the very beginning. An abstract basically is a section that provides a summary to your whole research articles. It is from 100 to 250 words and it outlines the findings and conclusions and the main points of your research paper. Just below the abstract, you write your keywords. Now, keywords are specific terms or phrases that you use to understand the topic. Say, for example, I have been talking about the law relating to maintenance. So, I'll write law relating to maintenance, then, comma, marriage laws, comma, I'll write alimony, comma, I'll write the section relating to maintenance laws. So, 4 to 5 keywords that helps the reader identify the relevance of your work is something that you need to mention in your keywords. Then we have the introduction part where we have the introduction to the topic and the background. The introduction basically serves the reader, you know, as an introductor of your topic. Say, for example, my topic is that law relating to maintenance are unjust to or are biased towards females. So I'll introduce the topic. I'll explain what the maintenance law is and why do I think it is biased. Then we'll go into the background of that particular law. That is from when the law started being applicable. Say, for example, it was applicable in 1860. That was before independence of our country, right? So I'll write the pre-independence concept in and the post-independence concept and the difference between the two. If there is any, I'll highlight them, and that will be the background of my particular topic. Background includes historical background, legislative background, and even relevant case laws. Then we have the main body, in which we have the main arguments, supporting evidences, and analysis. So the main arguments are what you want to explain through your article. Say, I want to explain that law relating to maintenance are biased towards females. How will I explain them? I'll collect data. I'll write my uh, theory. I'll explain that this particular law only talks about giving maintenance to females, or I'd say this, but out of the two laws, this laws talk about only giving maintenance to female, and even if it is given to male, it is only given during the pendency of the proceedings and at no other time. So I'll write that. Then I'll give supporting evidences. So in my particular research, if I have collected any data, say for example, I have done interviews and surveys, I'll organize them and fit them in my research paper. If I have referred to any case laws or commentaries, or if I have referred to textbooks, or if I've referred to any judicial decision, those will also be added as supporting evidence in my particular body. And then we have the analysis part. Now, after you have written your argument and you have written your evidence and you have attached your supporting evidences, then you'll analyze that what I want to say and what I want to explain is that using all this research and all this particular data, it is very clear that raw relating to maintenance is biased towards female. Then comes the summary part, the conclusion part. So in conclusion part, we have the summary and implications. Summary basically means we summarize all the concepts. That is, the what were my arguments, what have I found, or what is the conclusion of my article. That will be the summary part, which I'll write in conclusion. And then the implication. Implications basically means how my particular article has impacted the legal the policy making or the literature in much broader aspect. That is how my research contributes to the existing knowledge, or what research gaps does it fill. That will be highlighted in the implications part. So, firstly, there's the abstract and keywords. Abstract is basically summary of your whole article, including the findings and conclusions of your research, which is written in 100 to 250 words. And then there are keywords, that are specific phrases that we use to understand the main themes of our research paper. Then in the introduction, we have the introduction to our topic and the background, including historical background, legislative background, and relevant case precedents. Then we have the main body that encapsulates the arguments that I want to prove and has the evidence and reasoning of why I'm saying X, Y, Z. If I'm saying X, then why am I saying X? That is something that will be in my main body. And then there's the analysis part, that I have said this because from this particular evidences, it is clear that the law relating to maintenance or the law relating to XYZ is biased towards a particular section of the society. And then is the conclusion or summary part, in which we write what our findings were, or what I want to conclude from the article, and uh, then the implications of how my research has contributed to the existing knowledge or the decision making, or what gaps have I fulfilled, will also be written. Then the sources. Now, in the sources, we have three kinds: primary, secondary, and tertiary. Primary sources are the original sources of law that include statutes, regulations, case laws, etc. Then we have the secondary sources of law, which includes textbooks, scholarly articles, treaties, annotations, commentaries on laws, etc. Then we have the tertiary sources. Tertiary sources are a compilation of primary and secondary sources which are designed for the normal people, that is a person who is not a lawman, to understand. Now this includes dictionaries, legal guides, legal handbooks, citers, legal references, etc. So primary basically is the original source of law. Secondary is a work that is analyzed, or a commentary or an explanation of the primary sources. And the tertiary source of law is a compilation of both primary and secondary sources that is made for general understanding. Then, coming to the most important part, that is understanding what plagiarism is. Now, if you ever write your research article, if you ever write your research paper, whenever you read the guidelines that are given to you, you will see that there's a particular amount of plagiarism that is allowed. Usually, it is 5 to 10%, a maximum of 15% plagiarism that is allowed in your articles. Plagiarism basically means you have used other person's work in your article to write your article, that and you have also used your ideas as well. So, say for example, you are writing a research paper and you want to cite my ideas that I have written in my research paper. You copy paste my ideas in inverted commas and reference that this particular author has said this in his or her research paper. So the copy pasting of someone else's idea or using someone else's idea is known as and then not giving credit. Now, plagiarism is very unethical. Why? Because, say, for example, you're using someone else's work, or you're using an idea of some other author, and then you're not giving them due credit. That is known as plagiarism. Why is it unethical? Because just imagine someone has taken their time, done their hard work, and you're using that without even giving them due credit for their work. Obviously, it is unethical and it's also punishable. So that is what plagiarism is. And whenever you go for writing research papers or research articles or even essays for various websites, at that point of time, when you read their guidelines, they'll say we have a maximum of XYZ% of plagiarism allowed. Now, how can you avoid plagiarizing? The first is do not actively plagiarize. That is, try avoiding the urge to copy paste from someone else's article. But if you do that, then cite the sources properly. Say, for example, my article is relating to law of maintenance, and I have used something written in Paras Diwan's Hindu law book. Then I'll cite that particular book because that author has stated XYZ thing and I'm using it in my article. So I'll give due credit to that author by mentioning their name, their book's name, and what page number, from what page number, or from which paragraph I've copied it. Similarly, if I'm using Paras's ideas that he has written in his article, then I'll also write this side. I'll footnote it, or I'll write it in the bibliography part that this particular thing is taken from Paras's article, title this on page number so and so. That is something that you need to do if you have actually copy pasted. Then is the use of quotation marks. If you're ever copy pasting someone else's idea, use quotation marks, that is the double inverted commas that we use. Use them because that shows that this work is particularly cited. Then avoid the urge to paraphrase. People think that if they paraphrase, that is, you know, take one word and put it, if a person has written XYZ and I read ZYX, it will make my article plagiarism free, but it won't. So if you even paraphrase it effectively. Then attribute ideas. If you're using someone else's idea which they have said, or if you're using someone else's comment that they've made in their research paper, research article, or even the judges, when they give particular commentaries, if you're using them, mention their name and where you have read it or where you have seen that idea from. Then facts. Now, as I mentioned earlier, say for example, I'm using data and I'm citing the data of NCRB, that is the National Crime Records Bureau. It has mentioned a statistical data of the number of crimes committed against men in the particular year or in the particular month. This is a fact, but this is not known to the public, or this is not something that is easily that some person will randomly know. If I'm writing that the sun rises in the east, this is a fact that I can see, so I can do it. This is something that is widely known to all. I do not need to reference this. But if I'm mentioning something such as the NCRB data, then I need to reference that particular fact from where I've found it. And I also need to mention the um, correct URL and the correct citation for the same, so that in case a person wants to read that particular fact or wants to cross check what you have written, they know where to go. Manage your notes. So while you're writing your article, you'll always have a rough idea of or you'll always make a rough of these things, that this particular XYZ topic I need to read Legal Vidya's website and I need to cite it from there. So, what I do while writing articles at least is that I make two documents. One is a final draft and one is a note of the places where I've referred XYZ things from. So manage your notes effectively, and after you have done writing your article, see your notes and ensure that everything is properly cited. Then use plagiarism detection tools like this Dilbert, there is Turnitin, there are various other free tools as well that are available. The links to those will be given to you by your internship coordinator in your group. Some of them are, small SEO tools. There's I love PDF, there's Grammarly, there's Duplicator. There are hundreds of free plagiarism detection tools. Use those and ensure that your particular article is plagiarism free. And the last one is to seek guidance. Even after doing all this, if your article still has a lot of plagiarism, ask your teachers, ask your friends, ask anyone who has ever written a research paper on what they do to avoid plagiarism or how they avoid plagiarism to ensure, and what steps you need to take to avoid the particular thing. So seek guidance if you ever feel stuck. Now that is it that I had to explain for this particular session.